You may have heard that Clubhouse is being sued for trademark infringement. Now, unfortunately, journalists who wrote and lawyers who commented on this didn't really bother to dig deep into what actually happened before they wrote their articles or shared their educated opinions. If you go through these articles, you'd learn that Clubhouse never bothered to get a trademark on the name Clubhouse, and that the plaintiff, a company that nobody's ever heard of, is now trying to capitalize on the trademark that they've recently registered. Well, as you learn in this video, there's a lot more to the story, a lot. Like, for example, that the company behind the Clubhouse app does have a trademark registration that predates the one owned by the plaintiff. And yes, we'll go through that in detail in this video, so buckle up. Well, the one thing that is true is that Clubhouse is being sued for trademark infringement. Now, to be more specific, Alpha Exploration Co., the company behind Clubhouse, is being sued for trademark infringement by SBS Consulting Group LLC, an Arizona limited liability company that owns a trademark for the Clubhouse. The Clubhouse as one word. What I'm gonna do is I'm gonna go through the lawsuit and provide my comments as we go along. All right, at the top, they're listing all grounds of the lawsuit. We'll go through them in detail, but as a teaser, what they're claiming is that
Alpha Exploration infringed on SBS Consulting Group's registered federal trademark, engaged in unfair competition, diluted SBS Consulting Group's trademark, perpetrated consumer fraud under the laws of Arizona, committed common law trademark infringement under the laws of Arizona, violated Unfair Practices Act of California, committed common law trademark infringement under the laws of California, and committed common law unfair competition under the laws of California.
Ouch! Okay, first, they quickly discuss that the
U.S. Court for the District of Arizona has jurisdiction to hear the case.
Now, naturally, SBS wanted to sue on the home turf, and to link Alpha Exploration to Arizona, they make sure to specify that a significant number of customers of Alpha Exploration's Clubhouse app are in fact in Arizona. And the fun begins where they start talking about the parties of the case. All right, so SBS Consulting Group starts with itself.
In 2018, SBS founded The Clubhouse, a destination for current and aspiring sports business professionals to join a community, share resources, establish and grow a network, and collectively support career growth in sports business. SBS has been using The Clubhouse name in association with a social and business blogging, podcasting, and networking service related to sports topics and within the sports industry since at least as early as November of 2018. On May 31st, 2019, SBS submitted an application for a trademark registration with the USPTO for The Clubhouse in classes 35 and 41. On December 24th, 2019, the USPTO issued to SBS US trademark registration number 5943043 for the mark The Clubhouse.
And by the way, this registration came in just under 7 months, which is very quick for USPTO standards, since on average the process takes around 14 months. On December 24th, 2019, the USPTO registered their trademark for
providing network opportunities for individuals seeking employment, providing an online searchable database featuring employment opportunities, that's in class 35, and also education services, namely providing non-downloadable webinars and personal mentorship in the fields of business and career advancement in the sports industry, providing a website featuring blogs and non-downloadable publications in the nature of articles, podcasts, and newsletters in the fields of networking, job opportunities, and career advancement in the sports industry in class 41.
Why they list all their goods and services in the lawsuit? Well, because trademarks don't give you a monopoly over the name itself. They only give you a monopoly over the use of the name in connection with specific products and services for which the trademark is being registered. So they wanted to set up the field up front. Also, they attached a true and accurate copy of their trademark registration. Why? Well, because a trademark registration certificate creates a rebuttable presumption of ownership and validity, meaning that unless proven otherwise, SBS owns a valid trademark on the name The Clubhouse in connection with those goods and services I just read out to you. Okay, moving on to the lawsuit.
SBS has marketed and provided its social and business, blogging, podcasting, and networking services related to sports topics and within the sports industry, and the services identified in SBS's registered mark in commerce since at least as early as November 14th, 2018.
Here, they're trying to establish that they were there first. SBS's The Clubhouse services feature a community for individuals to network and grow their careers in sports business. And here again, they're trying to paint the services they're providing to be more in line with what Alpha Exploration's Clubhouse does, to be more of a community and network rather than just a website for sports professionals to find employment opportunities.
The focus of SBS's The Clubhouse services and content revolves largely around sharing industry knowledge, guidance, and best practices for consumers who are interested in growing a career in sport. While much of SBS's The Clubhouse services and content can often be job-related, their multi-platform content also includes knowledge and resources relating to sales, sponsorships, and marketing, social media, and analytics.
They know that the number one argument that Alpha Exploration is going to make is that their Clubhouse has nothing to do with sport careers. So what SBS is trying to do is they're trying to preempt that argument by inserting this paragraph to show that in fact, they have this multi-platform content about sales, sponsorships, marketing, social media, and analytics. Right? It's not their strongest point, but they had to make it. Okay?
SBS's The Clubhouse provides content to consumers through its blogs, more than 180 articles, webinars, more than 77 sessions. I love
how it's 77 plus. Why not 70 plus? Right? Is 78 77 plus? It's a weird number.
Social media accounts, more than 20,000 followers across all channels. Newsletter, 13,000 subscribers. And through its website, which garners approximately 100,000 page views per month.
Here, again, they're showing that while most people may not have heard about SBS or The Clubhouse, they're not a ghost website that nobody visits. 100,000 page views per month is over 3,000 page views per day, which is not bad at all. Now, 20,000 followers and so on. They're showing that they may not be the biggest player in the game, but they have accomplished something. They also mentioned that a part of the benefit that users get from online community of The Clubhouse is that
they get direct online mentorship, receive tips on their networking, resumes, and other career opportunity behaviors.
Same idea. Since the defendant's app is more of a social media platform built around an online community, SBS needs to frame their own services as an online community as well. Then they show a screenshot of their website, and they claim that
since its launch, SBS's The Clubhouse has become ubiquitous in its industry and has acquired a network of resources, contributions, and direct participation from well-known professional sports organizations across the MLB, NBA, NHL, MLS, WNBA, and NFL, amongst others. NCAA, sports programs, and other highly respected companies who offer services in sports business, such as ticket sales companies, hospitality companies, and a variety of other companies offering business, administration, and related management services for sports business.
Now, I was never interested in building a career in sports, personally. So I may be biased here, but I have never heard of SBS or The Clubhouse until this lawsuit was filed. Now, it doesn't mean that their allegation that they've become ubiquitous is untrue. Just saying that they may need a bit more than a mere allegation to get to that level with a judge and the jury. Then they say that their visitors can find job postings from some well-recognized companies. Now, that's great. They say that
their customers can find and directly communicate with mentors based on their discipline, just like Alpha's Clubhouse users can find, follow, and communicate with experts in various areas of expertise. Many individuals who work at notable sports business organizations participate as mentors to users of SBS's The Clubhouse services and contribute knowledge, facilitation, conversation, and foster professional relationships with such users. SBS's The Clubhouse currently boasts over 190 mentors, who each offer their services to members of SBS's The Clubhouse, which include participating in direct communication with members for the purposes of sharing advice, educational resources, and any other type of mentorship and assistance that is valuable from a networking standpoint.
Again, what they're trying to do here is that they're painting the picture that what they do, what SBS does, is pretty much exactly the same as Alpha Exploration's Clubhouse does, albeit Alpha's Clubhouse might be doing it on a much bigger scale.
Now, users of the SBS's The Clubhouse benefit not only from accessing job openings at highly regarded sports business companies and gaining exclusive mentorships from well-respected industry professionals, but are also offered a plethora of resources that expand their knowledge of sports business and facilitate networking and cultivate relationships. Of these resources, the webinars offered by SBS's The Clubhouse are some of its most popular and impressive. These webinars span across a variety of topics, feature many notable sports business professionals, and are oftentimes presented live. In sum, the resources and interactive participation options for users of the services provided by SBS's The Clubhouse are endless, and have created a community that had not otherwise previously existed for professional networking and career growth in sports business.
Their point is, we started doing the same thing first, and then Alpha came with their app and stole everything from us. That's the story that they're trying to make. Okay, so now that they've gone through what they do, it's time they talk about Alpha Exploration.
AEC, right, Alpha Exploration Co., was incorporated in about February of 2020.
They try to make the case that Alpha was incorporated after they got their trademark, okay? That may be true, but as you'll learn in a moment, it may not be enough. All right, upon information and belief, and that's the legal way of distancing yourself from saying, this is not a fact, this is as far as we know. And if we're wrong, it's not because we're trying to lie to you, it's what we know.
Okay, so upon information and belief, Alpha has used Clubhouse name for its iOS software application since May of 2020. Upon information and belief, AEC has used the Clubhouse name on its website since May of 2020.
Same idea. They're trying to make the case that they had been using the name, that SBS had been using the name before Alpha came in and stole it from them.
Through Alpha's Clubhouse iOS software application, Alpha allows consumers to participate and or listen in on conversations about a range of topics in real time. Users can pick topics of interest, and AEC's Clubhouse services will then recommend conversation rooms related to these interests. Users of AEC's Clubhouse services can also form or join clubs. Clubs are used to host a series of intimate conversations with a defined community of people. Users can specifically search for any type of topic and explore or join clubs related thereto. According to AEC Clubhouse User Guide, the goal of clubs is to grow into communities of people that come together regularly based on shared interests, identities, activities, and more.
Now, they're doing some advocacy work here, painting Alpha's Clubhouse activities through the prism of what SBS does.
When a user of Alpha's Clubhouse services joins, they're prompted to explore or search for people or clubs in any wide range of topics. They can also search for rooms which facilitate conversations in whatever topic the user may be interested in or feature specific participants that pique a user's interest. Once a user finds a person, club, or room of interest, they can interact, learn, and even connect with other members to build a community and network. Included in AEC's Clubhouse topics of interest and clubs are a variety of networking, career growth, and sports business category selection.
And then they provide several examples with screenshots. The goal is obviously to show that there's a huge overlap between the two companies that operate essentially under the same name.
That is a huge problem.
Users of AEC's Clubhouse can also explore by topic, including sports. Once the sports topic is selected, users may then choose to follow all types of sports professionals and will have the ability to access and participate in workshops, conversations, and other live events that include or involve sports professionals and cover topics in rooms that relate to career development in sports business. In other words, consumers using AEC's Clubhouse can search for any number of services offered in connection with SBS's registered mark and find such results offered instead by AEC's Clubhouse.
The counter argument to that, of course, would be that Alpha could provide statistics that would show that their users who are interested in topics related to careers in sports make up less than a fraction of 1%. Of course, I don't have the actual numbers, but that would probably be one of the lines of defense in this case. The lawsuit continues with a further attempt to show that Alpha's Clubhouse is essentially doing what SBS's The Clubhouse does.
They say that the services that Alpha offers may include participating in chats that cover topics common to SBS's The Clubhouse, webinars, connecting users of AEC's Clubhouse with sports business professionals who would be the same type of professionals that often serve as mentors on SBS's The Clubhouse, and overall facilitate a community on AEC's Clubhouse for those seeking career advice in sports business. Accordingly, AEC's Clubhouse, which was launched over a year and a half after SBS's launch of the similarly named The Clubhouse, shares several remarkable similarities in its services offered by SBS's registered mark and used thereof. Not long after AEC's Clubhouse launched, consumers began confusing its services for those offered under SBS's registered mark, thinking that the brands were related or the same.
Now, the reason they're bringing it up here is because in order to provide trademark infringement, the plaintiff must prove that when the defendant used a mark similar to the one owned by the plaintiff. 2, that the use of the mark was such that it created a likelihood of confusion between the plaintiff's mark and the mark used by the defendant. And 3, that the defendant did not have the plaintiff's permission to do so, right? And the best way to prove likelihood of confusion is to show multiple cases of actual confusion, right? If many people who used Alpha's Clubhouse were in fact misled into believing that they were about to obtain services from SBS, it's much easier then for SBS to prove the likelihood of confusion part of the lawsuit, right? So how are they doing it in this complaint? Well,
they state that consumers began confusing the two services because AC's Clubhouse targets the same consumers as SBS, offers the same services, and has created an online community using the same name to facilitate networking and career growth in sports business.
Right, this is all general. It doesn't provide any specific evidence. Now, here they provide some examples. They say, for example,
a user may intend to attend a happy hour networking event offered through SBS's The Clubhouse, or wish to watch a live webinar about sports business topics where they could engage in a live chat during the webinar and network with other attendees, but instead mistakenly obtain such services through AAC's Clubhouse, making confusion likely.
So again, it's just a hypothetical. It's not a real example of actual confusion. It's a hypothetical example of how that confusion could happen. And now they finally give a real example. They say,
SBS is aware of at least several circumstances of actual confusion. For example, an industry professional who was interested in becoming a mentor for SBS's The Clubhouse noted that he was confused as to which clubhouse was offered by SBS after realizing there may be two. This aforementioned industry professional is a professor and sports administrator at a university located in the United States.
Now, the reason they're saying that is that he's not some dumbo, right? That he's a professor and English is his first language. That's the reason they're saying he's, professor at the university located in the United States. Okay, so they say then
he reported that his students participate in chat rooms, online forums, networking, and engage in a mentorship program offered under the name Clubhouse, but was confused when he could not ascertain whether these students were truly using SBS's The Clubhouse as he believed they were, or instead whether his students were mistakenly confused into using AAC's Clubhouse.
Now, if that's all that SBS got in terms of evidence of actual confusion, it would be a far cry from being enough.
SBS also has a long-standing relationships with several professionals who work for the NFL and has developed relationships with several NFL teams. Upon information and belief, AAC partnered with the NFL to provide content related to the upcoming NFL draft on AAC's Clubhouse. The partnering of AAC's Clubhouse and the NFL for the draft with some of SBS's most important contacts likely caused further confusion, mistake, deception, and dilution, and may even directly damage the long-standing relationship SBS has with many NFL professionals and teams.
Their point, of course, is not that the NFL shouldn't work with other companies. It's that Alpha shouldn't be able to get away with working with NFL under essentially the same name as SBS.
SBS has worked tirelessly to establish significant goodwill and recognition with SBS's registered mark and the Clubhouse brand. This goodwill and wide recognition is due largely to participation by well-respected individuals and companies in sports business, to the offering of quality and successful programming and resources available online for customers to grow their career in sports business, and to overall successfully establishing a community to facilitate meaningful career growth and networking for consumers in the sports business industry as part of SBS's The Clubhouse. Importantly, SBS vets all participants and content available to the users of SBS's The Clubhouse in an effort to provide value to its users who want to grow their careers.
The reason they're bringing this up is to show that, hey, we provide much better services than this copycat. And while the copycat may have grown bigger than us, the quality of their services sucks compared to ours. So not only are they stealing our brand, they're also offering inferior services to their unsuspecting customers. And then they go on to say that
SBS's registered mark and SBS's The Clubhouse brand have acquired great value. as a specific identifier of SBS's services, have established significant goodwill, serve to distinguish SBS's services from that of others, have become associated with Clubhouse in the minds of consumers, and give SBS strong, valid, and enforceable trademark rights in the mark Clubhouse that are senior to whatever rights AAC may claim.
Interesting that they've dropped the from the Clubhouse at this point, okay? And again, we'll see about whether they really did have that strong, valid, and enforceable trademark right in a moment, okay? They also say
that consumers have been confused into believing that AAC's Clubhouse is affiliated with, sponsored by, or otherwise related to SBS, threatens to damage that goodwill. And as AAC's Clubhouse services do not provide the same level of scrutiny for its participants or clubs for the same or similar topics offered by SBS's The Clubhouse.
Okay, here again, our service is good, Alpha service is bad. I get it. All right, now they're back to discussing the elements of trademark infringement.
AAC's use of the Clubhouse name causes a likelihood of confusion with SBS's services. AAC's Clubhouse name is highly similar in appearance and in sound to SBS's registered mark, is used in connection with identical goods and services, and targets the same customers through the same channels of trade.
Again, this is advocacy. While I agree that the names are highly similar, from the trademarking perspective, there's hardly any difference between Clubhouse and the Clubhouse. Now, there would be no difference if the Clubhouse was two words, because SBS merged it into one. Alpha can make an argument that the first syllable of the name should be given more weight in comparing the two marks. It would be a losing argument, but it's a possible argument. But generally, adding the in front of a name doesn't change anything in terms of whether two trademarks are similar or not. So again, while I agree that the names are highly similar, to say that the services are identical and that they target the same customers, now that's quite a stretch. But let's go back to the complaint.
Without permission or authority from SBS, AAC has infringed SBS's registered mark in interstate commerce by making, using, promoting, advertising, selling, and/or offering to sell AAC's products and services under the mark Clubhouse.
Again, they need to allege that Alpha did not get a license from them to use the name, because if they had gotten that license, it wouldn't have been a trademark infringement for them to use it.
SBS is informed and believes, and on that basis alleges, that AAC's unauthorized use of the mark Clubhouse is intended to trade upon the goodwill and substantial recognition associated with SBS's registered mark and the Clubhouse brand. SBS is informed and believes, and on that basis alleges, that AAC is using the Clubhouse name in an attempt to associate its services with SBS's services and SBS's registered mark, and to cause mistake or deception as to the source of AAC's services and/or otherwise trade upon SBS's valuable reputation and customer goodwill in SBS's registered mark and brand. SBS is informed and believes, and on that basis alleges, that AAC's use of the Clubhouse mark is designed to cause confusion, mistake, or deception.
And again, here SBS is basically trying to say that Alpha is the bad guy here.
By virtue of the acts complained of herein, AAC had created a likelihood of injury to SBS's business reputation, has caused a strong likelihood of confusion, mistake, and deception as to the source of, or origin, or relationship of SBS's and AAC services, has diluted its famous The Clubhouse brand, has caused actual confusion, and has otherwise competed unfairly with SBS by unlawfully trading on and using the Clubhouse name, a substantially similar mark to SBS's registered mark, without SBS's permission or consent. SBS is informed and believe, and on that basis alleges, that AAC's acts complained of herein are willful and deliberate. AAC's acts complained of herein have caused damage to SBS in an amount to be determined at trial, and such damages will continue to increase unless AAC is enjoined from its wrongful actions and infringements. So
this opens the door for SBS to seek a preliminary injunction that would force Alpha's Clubhouse to stop operating until the trial has been completed. Now, there's no chance in hell the injunction would be granted, since the standard of what you need to prove to get one is very high. And preliminary injunctions are very rarely granted in intellectual property lawsuits. You need to prove that if the injunction is not granted, you will suffer harm that cannot be fixed by monetary award, and that forcing the defendant to stop using your trademark would create a smaller inconvenience to the defendant than the harm that they're going to cause to the plaintiff. Now, in words of the plaintiff,
AAC's acts complained of herein have caused SBS to suffer irreparable injury to its business. SBS will suffer substantial losses of goodwill and reputation unless and until AAC is preliminary and permanently enjoined from its wrongful actions complained of herein.
Here we go, right? That's the preliminary injunction request. And here we're getting to the real fun part.
Upon information and belief, AC has not submitted any applications with the USPTO for a trademark registration of Clubhouse for its services in the United States.
That's the line that most journalists and lawyers parroted from the lawsuit. Had they spent a couple of minutes searching the USPTO website, they'd quickly learn that this is not the case. So let's pause with the lawsuit and go through the various trademark applications and registration that may be relevant in this case. Now let's start with the bomb. Alpha Exploration Co. actually owns the Clubhouse trademark, filed on July 29th of 2015 and registered on March 1st, 2016 in connection with
computer software development in the field of project planning, management, and collaboration software. Platform as a service, featuring computer software platforms for project planning, management, and collaboration. Providing temporary use of online, non-downloadable software and applications for project planning, management, and collaboration. Software as a service services, featuring software for project planning, management, and collaboration.
Now, if you're paying attention, you may be wondering, hey Andrei, didn't you say this trademark was filed in 2015? Why does SBS then say that Alpha Exploration Co. was incorporated in 2020? Well, I'm glad you asked. While the trademark is now owned by Alpha Exploration Co., it was initially filed in 2015 by a company with a different name. Want to know what the name of that company is? Clubhouse Software Inc., a Delaware corporation. According to Wikipedia, Clubhouse Software was founded in 2014 by Kurt Schrader and Andrew Childs, with the aim of bringing more transparency and predictive models to the process of software engineering. After a year in beta, its flagship product, a project management platform called Clubhouse, was launched in 2016. And Wikipedia specifically mentions that Clubhouse Software has no relationship with the invitation-only audio chat app of the same name, which launched on iOS in April of 2020. The identical names of the two apps have regularly caused confusion since the chat app's launch. For example, in February 2021, after Elon Musk announced that he would make an appearance on the platform, Android users looking for the chat service review bombed Clubhouse Software's Android app, causing the company to pull the app temporarily. So then, what does Clubhouse Software have to do with Alpha Exploration? Well, on April 29th, 2021, Clubhouse Software assigned all of its rights in their trademark to Alpha Exploration. That's how Alpha owns this trademark right now. Now, interestingly, even though Clubhouse Software assigned its right to the name to Alpha Exploration, they continue to sell their project management software under Clubhouse brand at clubhouse.io. It means that they must have gotten a license back from Alpha to do so. But you may say, sure, Alpha bought someone else's trademark that covered project management software to have a good defense in court. Big deal, but that's not all. This is where the fun begins. Once again, if you're paying attention, you may have noticed that the assignment from Clubhouse Software Inc. to Alpha Exploration was made for 3 trademarks. One was the registered trademark filed by Clubhouse Software in 2015. The other 2 were for trademarks that Clubhouse Software filed in September of 2020. One was for the Clubhouse logo in Class 9 for downloadable computer software for product and project management, product and project planning, collaboration, and team communication. And in Class 42 for
computer software development in the field of product and project management, product and project planning, collaboration, and team communication software, providing temporary use of online, non-downloadable software and applications for product and project management, product and project planning, collaboration, and team communication, platform as a service, featuring computer software platforms for product and project management, product and project planning, collaboration, and team communication, and then software as a service, services featuring software for product and project management, product and project planning, collaboration, and team communication.
Now, the other one is for the name in Class 9 for downloadable computer software for product and project management, product and project planning, collaboration, and team communication. So as you can see, both these new trademarks are very much still all about project management. Now, What's interesting about those two new trademark applications is that they both received an office action stating that there are other confusingly similar trademarks that may block registration. Oh, and the crazy part is that the Clubhouse trademark owned by SBS wasn't even mentioned in those office actions. Instead, the office actions named the following trademarks: the Clubhouse, where technology meets imagination, filed in 2015 and registered in 2019 by the Clubhouse Network, Inc., among other things, for
providing a website for registered users to participate in discussions and engage in social networking related to computing, digital media, and technology, as well as conducting classes, workshops, educational demonstrations, educational exhibitions, mentoring, tutoring, and guidance in the fields of academics, life skills, problem solving, all related to computing, digital media, and technology.
Sounds familiar, right? And the office action also mentions a prior pending application for Clubhouse filed on July 28th of 2020 by Alexander Fredrickson in Class 9 in connection with application software for social networking services via internet. And to make things even more fun, Alexander Fredrickson's own trademark also got an office action because of two other trademarks: Clubhouse Games, right, filed on July 2nd, 2020 by Nintendo. The mark has been published for opposition on April 27th of 2021. This trademark was filed in Class 9 for video games. And also the other one that's blocking Alexander's mark is Wormhole Clubhouse, filed in March of 2019 in connection with software that gives users the ability to upload, exchange, and share content relating to audio, video, text, binary, still images, graphics, multimedia files, and computer games via an online portal. That trademark has been allowed, and the USPTO is waiting for the applicant to file a statement of use. So let's summarize this. Alpha bought 3 trademarks from Clubhouse Software. One of them is registered for project management software. The other 2, also primarily for project management software, received office actions because of alleged likelihood of confusion with other previously filed applications. Not one of those applications mentions SBS's trademark, and also some of those applications are even closer to what Alpha actually does than what SBS's trademark actually covers. So how will any of this help Alpha? Well, let's continue reading the lawsuit and find out.
Upon information to believe, had AAC searched for or attempted to determine whether other names or trademarks exist which include the word Clubhouse in connection with AAC services or social and or business blogging, podcasting, and or networking services, AAC would have easily found SBS's trademark, the Clubhouse, being used in commerce. As such, AAC has either willfully blinded itself from SBS's trademark or has acted willfully and intentionally in relation to AAC's knowledge of SBS's trademark.
Right, and they're actually making a good point that had Alpha Exploration done a little bit of research, they probably would have come up with a different name, because there are so many Clubhouse trademarks there being pending, one blocking the other, and then the other, and then the other. It's a whole chain that it's a complete crapshoot that will be very difficult to untangle, right? SBS, of course, is trying to make the case that the only Clubhouse that matters is theirs, but it's a much bigger for Alpha than that. Yeah, and going back to SBS, here they're making the case that Alpha could have easily found out about SBS's trademark, but chose to ignore it and move forward with building their app anyway. This is actually a good argument in the sense that a business owner who knows about someone else's trademark standing in their way, and in this case there are multiple, right? And who nonetheless chooses to continue building a brand that's confusingly similar to the registered trademark, that business owner is playing with fire. And then the lawsuit goes through the various claims that they're making, and I've listed them in the opening of this video, so let's quickly go through them. Count 1, federal service mark infringement. Oh, and if you're wondering, there's no legal difference between a service mark and the trademark. There used to be a time when trademarks only covered physical products while service marks only covered services, but not anymore. Currently, trademark can apply to both products and services. Okay.
Here, SBS claims that despite SBS's well-known and prior established rights in their trademark, and without the authorization of SBS Alpha used and imitated the name Clubhouse in connection with the sale, offering for sale distribution of AC social and business blogging, podcasting, and networking services in U.S. commerce to the same actual and potential customers, users, and business partners as SBS's actual and potential customers, users, and business partners. Also, they claim that Alpha's use of Clubhouse in connection with AC's social and business blogging, podcasting, and networking services is likely to cause confusion and mistake with SBS's use of the Clubhouse in connection with AC services and infringes SBS's trademark registration. AC's infringement of SBS's registered service mark is detrimental to the goodwill and business reputation symbolized by the Clubhouse mark, and all of the foregoing conduct by AC infringes SBS's rights in the Clubhouse mark and causes SBS irreparable harm. SBS has incurred and continues to incur monetary damages. AC has realized and continues to realize profits from such infringement, and AC's actions of infringement have been willful and intentional.
Number 2, federal unfair competition. Now, the wording is very similar to trademark infringement, except the focus here is on the allegation that Alpha's actions
will cause confusion, mistake, or deception among the public and are likely to injure SBS by direct diversion of sales and or by diminishing and destroying SBS's goodwill with the same actual and potential customers, users, business partners as SBS's actual potential customers, users, and business partners. Count 3, federal trademark dilution.
Now, this is probably the weakest claim of all.
SBS claims that through their extensive, continuous, and successful use and promotion of the Clubhouse mark, the mark is widely recognized by the general public within the sports community and industry of the United States as a designation of source of SBS's services. Accordingly, they say the Clubhouse trademark is famous within the meaning of the law.
Well, according to the Act, in determining whether a mark possesses the requisite degree of recognition so as to be considered famous, the court may consider all relevant factors, including the duration, extent, and geographical reach of advertising and publicity of the mark, whether advertised or publicized by the owner or third parties. Number 2, the amount, volume, and geographical extent of sales of goods and services offered under the mark. Number 3, extent of actual recognition of the mark. And 4, whether the mark was registered. Now, with all due respect to SBS, they founded their website in 2018, and to claim that their trademark has reached the point of it being considered legally famous is a huge stretch.
It's a huge problem.
They need to prove it before they can claim that Alpha's use of a similar marks impairs the distinctiveness of the Clubhouse trademark and thereby lessens its capacity to identify and distinguish SBS. So again, until they prove that the mark is famous, it's hard for them to argue dilution, and they really want to. Count 4, Arizona consumer fraud. In addition to federal claims, SBS goes for state claims and those based on common law.
They are claiming that Alpha used a deception, a deceptive act or practice, a false pretense, or a misrepresentation to get SBS's actual and potential customers to use Alpha services.
Count 5, Arizona common law trademark infringement. Now, while registered trademarks protect you on the federal level, in the US, you may also have common law rights in your brand that are as geographically extensive as the fame of your brand goes. Basically, if you can prove that a significant portion of the relevant public have come to recognize your brand as a designation of the source of your products and services, you may claim common law rights. Now, this doesn't work in most countries, but it does work that way in the US and in Canada. So here,
SBS is claiming that they have made their brand known enough in Arizona in connection with marketing and provision of social and business blogging, podcasting, and networking services related to sports topics within the sports industry long prior to AC's adoption and first use of the name Clubhouse.
Why do they need this claim here? Well, because it goes outside of what their actual trademark was registered for, and they need to make sure that the online networking component is sufficiently covered. Now, because remember, the registered trademark is all about job opportunities, not about blogging, podcasting, and networking. Hence, the need to also rely on common law. Count 6, California Unfair Practices Act. Now, why do they also mention California law? Well, because this is where the defendant is based. This is very similar to what they've done in the section about Arizona consumer fraud. Count 7, California common law, trademark infringement. Again, same idea here. SBS claims that
AC's unauthorized conduct also has deprived and will continue to deprive SBS of the ability to control the consumer perception of its social and business blogging, podcasting, and networking services offered in connection with the Clubhouse trademark, placing the valuable reputation and goodwill of SBS in the hands of AAC, over whom SBS has no control.
And finally, count 8, California common law unfair competition. Again, pretty much the same thing we've already discussed. Now finally, what does SBS want? They want the court to confirm that they own a valid trademark and the exclusive right to the name in commerce. Well, that one is easy. The question is, what does their trademark cover, and does it cover enough to stop Alpha from using a virtually identical name for their platform? SBS also wants the court to find that Alpha infringed on SBS's trademark and that it diluted and tarnished SBS's famous mark. SBS is asking the court to find that Alpha has competed unfairly with SBS and that it has committed consumer fraud, and as a result, SBS wants the court to stop Alpha from using the name Clubhouse in its app, on this website, social media, or otherwise in connection with social and business blogging, podcasting, and networking services. SBS is asking for all profits that Alpha has received from their platform and any other actual damages sustained by SBS. Now, obviously, SBS's actual damages are going to pale in comparison with Alpha's profits, given that Alpha's Clubhouse valuation exceeded $4 billion in April of 2021. SBS is also asking for attorney fees. Okay, so here's my prediction of what's going to happen next. Alpha will claim that there are just too many clubhouses that peacefully coexist in the marketplace for SBS to claim that Alpha's app is infringing on the one owned by SBS. They will claim that SBS's trademark is very narrow in that it only covers career opportunities in sports. That has nothing to do with general social networking. The whole thing will go on for some time. Lawyers on both sides are going to have a lot of fun filing pleadings and motions, but most importantly, sending invoices to their respective clients, citing hundreds of billable hours that went into filing these pleadings and motions. Both sides recognize that there is no way the court would order Alpha to pay SBS the entire profits generated by the app. In the best case scenario for SBS, it would be awarded a fraction that represents the subset of users interested in building a career in sports. Now, how big that fraction would be is uncertain, and that would be one of the biggest issues for the sides to argue about. Now, in the end of the day, I expect Alpha to make SBS an offer that SBS will not be able to refuse, and the case will quietly go away. It will be an amount that's less than Alpha's worst case scenario, but still a windfall for SBS. So what's the moral of the story? Will this be a story of a Goliath crushing the little guy again? Well, quite the opposite. Trademarks are assets that give their owners options. Without a registered trademark, SBS would have no case at all. I mean, yes, they could have relied on consumer fraud in Arizona and common law trademark rights in California, but they'd be laughed out of court with those allegations. The fact that SBS has a registered trademark is the only reason Alpha now has to take them seriously. SBS has an asset, a bargaining chip. And the fact that Alpha ended up buying up the trademarks from the project management company should give SBS owners a good feeling of where this whole thing could be going. Yes, the bigger company may end up gobbling up the small player, but don't forget one thing. A business is a tool that allows its owners to accomplish certain personal and professional goals. A deal with Alpha could generate more cash for them than decades of hard work on their original website. And they can keep their original website and audience, maybe just simply change their name. Now, of course, they may choose to fight all the way. They might even win something, but realistically, I don't believe that this is what's going to happen. I don't think that this is what the lawsuit was filed for. To me, this lawsuit reads more like a make me an offer letter. Now, time will tell. Now, could Alpha do something differently in this case? Yes, and not just in this case. The fact that they chose a name that has been used by several companies in their space speaks volumes about Alpha's failure to pick a brand that they could call their own. Because guess what? It's not going to end with SBS. I can guarantee that other Clubhouse owners will be knocking on Alpha's doors soon as well. Now, I always say that there's no reason in the world to spend a minute of your life or $1 out of your pocket building a brand you don't own. Alpha could have chosen any other name for their app and avoided the confusion in the marketplace altogether. Yes, they may pay their way into becoming the only Clubhouse out there, but it will cost them 1,000 times fold compared to what it would have cost them if they had picked a unique brand and trademarked it right away. So while they may be able to get away with using their deep pockets, it's still a good lesson for entrepreneurs who are just starting out. Pick a name that you love, check if it's unique enough to be trademarkable, and if it's not, go back to the drawing board and come up with a new name. Once you have picked a name that's trademarkable, don't wait another minute. Go out there and trademark it. The cost of protecting the brand will be negligible compared to you having to fight over it in the future. And even if your project doesn't go as big as you had hoped, who knows? Maybe one day some $4 billion company is going to end up buying that brand from you for more money than you've ever dreamed of. So post a comment below and let us know what you think about this dispute. And if you're a business owner who's building a brand, and if you haven't trademarked that brand yet, what are you waiting for? Go to trademarkfactory.com and request your free call with one of our strategy advisors who'll be able to answer all your questions and get you started if you feel there's a good fit. We're the only firm in the world that offers trademarking services with a guaranteed result for a guaranteed budget. We'll help you make sure that what you're building is your brand and nobody else's. And until then, I'll see you in the next video.
Get a trademark.